Good morning. Will the Committee on Zoning please come to order? At this point in time, I'd like to welcome committee members Cordero, Radiant, say hi to everyone. Nah. Vice Chair Tyler DeSantos Tam, Tyler, Council Vice Chair Esther Kiaina, Esther is here, and also Council Member Wire.
Hi.
Coming along now, doing his jog, I mean, not even a jog, a stroll, is Council. Although remote oral testimony is being permitted, this is a regular in-person meeting and not a remote meeting by interactive conference technology under Hawaii Revised Statute, Section 92-3.7. Therefore, the meeting will continue, notwithstanding loss of audiovisual communication with remote testifiers or loss of the public broadcast of the meeting. Members of the public will be allowed to provide oral testimony on all items on the agenda in two ways. First, remotely, and in person in the council chamber. Oral testimony will be allowed when each agenda item is taken up in the following order. First, we have remote testimony, and then, secondly, it will be the in-person testimony in the council chamber. Before testifying, each person shall state their full name and the agenda item they are testifying on. Each speaker may not have anyone else read their statement and is limited to a 1-minute presentation per item. All persons who have registered to testify remotely by video conference or phone will be called upon first. When your name is called, please monitor your screen and activate your audio feed when prompted. The following are some friendly reminders and tips. Video conference from a quiet location if possible. If you are watching the proceedings on Olelo, please mute your device at the time you are called to testify. When the timer on the screen reaches 0, please conclude your remarks promptly. For those who are joining us by telephone only, please press *9 to indicate your desire to speak. I will identify you by the last 3 digits of your phone number, and when your number is called, please press *6 to unmute yourself when prompted. Once all the remote testifiers have testified, I will then proceed to the in-person testimony in the council chamber. Persons who have not registered will be given an opportunity to speak following the oral testimonies of the registered speakers. Written testimonies, including the testifier's address, email address, and phone number, will be available to the public as described on the posted agenda. As a courtesy, please turn off all cell phones. Members, let's proceed on to the journey that we have this morning. Agenda item number 1, Resolution 24-124. This resolution grants a special management area major permit and the shoreline setback variance to the University of Hawaii to allow the installation of a wastewater sump, 2 on-site injection wells, equipment for disposal of the Waikiki Aquarium exhibit wastewater, and associated appurtenances. Construction of a filter housing building, upgrades to existing piping in the existing buildings and on the property, and associated earthwork on an approximately 2.35 acre shoreline lot, zoned P2, General Preservation District, within the core area of the Diamond Head Special District, located at 2777 Kalakaua Avenue, and identified as tax map key 3-1-031:006. Members, we have posted to the agenda a proposed committee draft 1 version of the resolution, and for your information, a summary of the amendments is listed on the agenda. Okay, now joining us in the council chamber, we're very honored to have Mr. Brandon Shima from the University of Hawaii, who will be providing a brief presentation. And we also will have Ms. Lisa Detzel Ma from the university, as well as Jason Lee. Berna Sanelli from Oceanet is standing by remotely and will be available for any questions that the members may have. For your information, the presentation is available online as Miscellaneous Communication 233 of 2024. So at this point in time, Mr. Shima, are you here? Thank you. Brandon.
Good morning, council members, chairs. My name is Brandon Shima. I'm with the University of Hawaii Office of Project Delivery. Our office takes care of all the major capital improvements for the University of Hawaii, along with any major renovations. The Waikiki Aquarium wastewater system upgrades is one of our projects. So just to give you a history of the Waikiki Aquarium. The Waikiki aquarium first got started in the early 1900s, 1904. That was the first facility that was built. The second facility, which is the current facility in its current location, was built in about 1955. Since then, all the current infrastructure is pretty much from that existing original construction when rules and regulations were a lot less stringent than what it is today. Over the years, with all the discharge from the exhibits, we are not able to meet the current federal, city, and state regulations. So this is the purpose of the project. So what you see on the screen now is the kind of overhead view of the current location of the Waikiki Aquarium next to the natatorium and its project limits. This is what the project is going to entail. It's kind of hard to make out, but there's two lines that go out into the ocean. One is the intake piping and one is the discharge piping. The discharge piping is what is in violation currently with EPA standards. Over the years, the turbidity levels, which essentially the cloudiness of the water that gets discharged into the ocean, those limits currently get more stringent, and we are no longer able to meet those current federal regulations. And the Department of Health, which enforces those federal regulations, has recently issued us AOC, Administrative Order of Consent, to get out or to stop discharging the exhibit water into the ocean. What's interesting, though, is that the turbidity or the cloudiness of the water, the intake water that we get in from the ocean, changes over the years. As storms come in, the times of the day. So in most cases, the water that we intake from the ocean is actually worse condition, cloudiness, than the water we discharge because we filter it on site. It goes to the exhibits, of course, but then it gets filtered before going back into the ocean. So it is actually cleaner, but it still does not meet the federal regulation standards. That's the reason for the project to discharge the exhibit water on site into injection wells. So it's kind of a summary of the notice of violation I explained. And the solution is the injection wells. So basically the injection wells is a 200-foot deep hole in the ground. The hole is relatively small. It's about 16 inches in diameter. And we're going to be putting two of these on site, on property of the Waikiki Aquarium, and essentially we're going to pump the discharge water from the exhibits into that injection well. This is a very similar system to what Sea Life Park is currently using in Waimanalo. Sea Life Park, actually, because they have so much larger exhibits, they actually have a bunch more injection wells. This project is going to be only installing 2 injection wells on property of the aquarium, along with all the infrastructure, pumps, piping, filtration system is also part of the project, all on property. This slide is the final solution with the project, showing the kind of the piping and the infrastructure routing, but again, all on property of the Waikiki Aquarium. And why this project benefits the state along with the surrounding communities is because we're essentially getting out of discharging from into the surrounding oceans and discharging into the ground, which has less stringent requirements than discharging into surface bodies of water. That's it. Questions?
Okay, members, any questions for Mr. Shima? The chair has one question, Mr. Shima.
Yes.
Have you made this presentation before the St. Louis Heights Diamond Head Kapahulu Neighborhood Board?
I'm sorry, could you repeat the question?
Have you made this presentation to the St. Louis Heights Diamond Head Kapahulu Neighborhood Board?
Yes, we have. And we haven't gotten any major comments back. And we also have went with the draft EA as well, and we have not got any significant comments.
Okay. Members, any questions for Mr. Shima? If there is no questions, thank you very much. So Lizzie, would you like to say a few words? No? Or you just here as a backup for Brandon? Okay. And also Jason, backup. Backup. Yeah? Okay. And then Berna? Is Berna here? Oh, she's online. Berna, anything you want to add on at this point in time from Oceanet? Or could you unmute yourself? There you go.
Everything was covered. Thank you.
Okay. Members, any questions for the contractor, developer, etc., the University of Hawaii? Okay. Brandon, thank you very much. At this time, we have Ms. Dawn Takeuchi Apuna, Director of Department of Planning and Permitting.
Thank you, Chair. The department is supportive of this SMA, and we have staff here to answer any questions.
Okay.
Thank you.
Members, any questions for the Department of Planning and Permitting and her staff? If not, okay. Thank you very much. We'll now, Madam Clerk, we will go into remote testimony. Madam Clerk, do we have any remote testifiers?
Yes, Chair, we have one standing by.
Okay. Oh, it's Ms. Young. Okay, would you, please proceed, Ms. Young.
Aloha, Chair and the committee. Angela Melody Young, testifying in strong support of the University of Hawaii and their project to mitigate the Waikiki Aquarium disposal for wastewater in the preservation district. And that plan for management of discharge is just so incredible. And I'm just wondering, I'm curious as a concerned community member, if the rules are different because it's in a preservation and a special management area district. So also, I'm curious if they tried the Genki balls, which works with Department of Health to mitigate the water and the ocean at the Alawai. I think
Ms. Young, your time has expired. Would you like to summarize your statement? Would you like to summarize your testimony or statement in support of the project?
Yeah, in support, because the Genki.
I just had a question for DPP, if possible.
Yes, please. Alex, please
Hi,
come on
good
up.
morning. Hey, can you explain for the committee and those watching online what a shoreline setback variance is?
Yes, good morning, council members. Alex Beatty with DPP. A shoreline setback variance is a request to have the rule waived. And in this case, that rule is a prohibition on activities in the shoreline setback area. So for shoreline setback variances, there are standards of review. In this instance, the standard of review is based off of what we call what the law calls the public interest standard. So we utilize that to review the request and are recommending approval of their variance. So in this case, the variance would allow them to do these activities, dig, trench, install, things that would otherwise not be allowed. Because within the shoreline setback area, there is otherwise a prohibition on all activities.
And the shoreline setback in this area is how many feet?
Starting next month, it'll be 60 feet. It is 40 feet right now.
Okay. And so anytime anyone wants to build within the setback area, they need a shoreline setback variance, right?
Correct.
And I noticed within the packet, there's a finding of fact and conclusions of law and recommendations. Is that what's necessary? Actual findings of facts and conclusions of law for this type of activity?
Yes, it is.
Okay. And this findings of fact and conclusions of law is prepared by your office?
That is correct. So in this case, because it's a SMA major permit as well, it is a recommendation to the council.
And is there some sort of hearing that goes on within DPP before this findings of facts and conclusions of law are prepared?
Yes, we hold a public hearing. because this one has an SMA major permit attached to it, we held the hearings concurrently. And we had one person came to the hearing, one member of the public attended the hearing, but they provided no testimony.
Okay, thank you so much. That was really helpful.
Sure.
Thank you, Chair.
Members, any further questions for the Department of Planning and Permitting? If there is none, members, at this point in time, there are no other testifiers. The chair would like to recommend that Resolution 24-124 be amended to the Committee Draft 1 posted on our agenda. Members, any discussion? Any objections or reservations? Hearing none, the resolution has been amended to a Committee Draft 1. The chair then recommends that Resolution 24-124, Committee Draft 1, be reported out for adoption. Any discussions, objections, or reservations? Hearing none, so ordered. Mr. Shima, best wishes to you on your project, and I hope you can get it done before the year is out. No, I'm only kidding. Okay, moving on to agenda items number 2 and 3, which we will take up together. Resolution 24-141. This resolution would direct the Department of Planning and Permitting Director to process a proposed land use ordinance amendment relating to administrative enforcement. Bill 6 of 2024, this bill relates to permits. Members, we have posted on the agenda a proposed Committee Draft 1 version of the bill submitted by Council Chair Waters, and for your information, a summary of the amendments is listed on the agenda. At this point in time, I will defer to Council Chair Waters to explain both Resolution 24-141 and his CD1 or Committee Draft 1 version of Bill 6 of 2024.
Thank you so much. As you mentioned, Resolution 24-141 would direct the DPP Director to process a proposed land use ordinance amendment, which is attached as Exhibit A to the resolution, that would provide DPP with more options to serve notices of violation and notices of order on persons that violate the LUO. Currently, enforcement notices may be served on the violator by registered or certified mail with return receipt requested, or in person. Alternatively, enforcement notices may be served on the violator by leaving a copy of the notice at the violator's residence, place of employment, or usual place of business, or by physically posting a copy of the enforcement notice in a prominent place on the property. But these alternative methods can only be used if the DPP first attempted to serve the violator personally or by registered or certified mail. If the DPP is not able to serve an enforcement notice by any of the methods previously described, the notice may be published once a week for 2 consecutive weeks in a daily or weekly publication of general circulation in the city. Most of us are aware of instances where a violator deliberately avoids or refuses to accept service of enforcement notices to evade the DPP's enforcement efforts. And often time is of the essence to prevent an LUO violation from becoming worse, or to prevent situations that may be difficult to undo, especially if the notice includes a cease and desist directive. My proposal would provide the DPP with more options to serve enforcement notices by allowing DPP to serve a copy of the enforcement notice at the violator's residence or place of employment, or by physically posting it on the property without having to first attempt to serve it in person or by registered or certified mail. My proposal on CD1 to Bill 6, 2024 would make the same amendments to the enforcement provisions in ROH Chapter 16, which is the building code, and ROH Chapter 18, which covers fees and permits for the building, electrical, plumbing, and sidewalk codes, as the amendments to the LUO enforcement provision that we discussed for Resolution 24-141. The CD1 would also make the administrative enforcement provisions consistent among the LUO, building code, and ROH Chapter 18. Thank you, Chair.
Thank you, members. Any thoughts at this point in time? Councilmember DeSanto Stamp.
Thank you, Chair. And I want to thank Chair Waters for bringing up both of these measures. You know, we've always had a challenge with DPP being able to meaningfully enforce on some of these more egregious violators, especially those who prevent the inspectors from entering into their properties. So I think that these are both very positive measures that will hopefully enhance DPP's ability to enforce. I do have a question for DPP if they're available. This may
Director
also be a
Apun.
question for Core. For Bill 6, at the end of Bill 6, section, the newly proposed C1, it says that if the building official is unable to obtain the consent of a property owner to carry out its duty, they can obtain a warrant issued by a circuit or district court judge upon, 1, proper oath or affirmation showing probable cause. So with respect to that, who is able to make such an oath or affirmation? Is it the inspector? Is it a neighbor? Is it perhaps an HPD officer?
I think it could be any of those, from what I understand.
Okay, good to know. So an HPD officer can make an oath, or under Bill 6, can make an oath or affirmation that they believe that there's probable cause for a building code violation. And thus DPP should then go in and enforce. Is that what I'm reading?
I believe so, but I would need to look at it carefully.
Yeah. And then for C2, an order issued by court of competent jurisdiction that authorizes a building official to enter a private property to abate a public nuisance. How is public nuisance defined? Because it's not currently defined in Chapter 18 at all. So what definition of public nuisance are we relying on?
I believe it's in the housing code that there's a definition, and I don't have it. Maybe I do. Under 16A.
So that's purely under the housing code. What happens if there is a owner of real property that is commercial or industrial in nature? It's not a housing code issue.
It probably wouldn't it wouldn't be covered under the housing code.
So if somebody is undertaking a public nuisance in a commercial or industrial zone or a preservation zone or an ag zone, this bill wouldn't affect them.
This bill,
Well, the provision from a court order would not allow a DPP inspector to go in under a close reading of this.
I'm not sure. I'd have to look at it. There's a lot of
This might be a good question
details.
for Core at some point, or maybe we can deal with it before a future hearing. But I ask these questions because, as you know, I've been pushing very hard on these game room bills, and we've gotten some pushback, I think, as to whether an HPD officer can actually show probable cause, relay that information to DPP, and thus DPP can go in and enforce. And yet in Bill 6, I see that this is perhaps in writing in black and white. Anyway, that wasn't a question. That was a rhetorical statement. No further questions for me. Thank you.
Okay, Director Apun.
Thank you, Chair. So we appreciate these two items, the resolution and the bill, because we would like to have the option for inspectors to post the notice, et cetera. I would defer to legal as far as that's possible. I think we've always wanted that, but that hasn't been maybe an option on a legal basis. For the resolution, just a couple of things. Let me see, sorry. We would suggest taking out on page 2, D6, a statement of actions that are necessary to correct the violation. We'd prefer just providing what the violations are rather than kind of providing any guidance on how to correct it. I think the violation itself should be sufficient for our purposes. The same goes for Bill 6. I think it has the same language. And then also under Bill 6, there's a change from erect to install, and I would like to speak with staff more about that. I don't know if we necessarily install structures so much as erect them. It might just be a fine difference, but that's something that we are looking at more closely. And then lastly, our intent was to take not just the LUO and the building code enforcement provisions entirely, including the notice provisions, but also all of the other enforcement provisions that are very similar but are organized by chapter. So there's the building code, housing permits, grading, plumbing, LUO, flood, SMA, and shoreline. And I hope I have all of them, but that's all the various ROH chapters that we have that include very similar enforcement provisions for notice, administrative enforcement, judicial, criminal, et cetera. So I think we would hope that this measure could do this, but it's not. But we are working on a draft that would condense all of the DPP's enforcement provisions, potentially under a separate chapter. But I think this is something this bill and this resolution can help more quickly address the issue about notice, et cetera. Thank you.
Okay, thank you very much. Any questions for the director? Chair Waters, this is your measure.
Thank you. Thank you, Director. Did you submit testimony to the committee regarding the suggested changes today?
No, I did not.
Okay. I mean, I'm happy, assuming that the chair is happy to entertain them. Can you go over them line by line?
Sure.
Exactly what
I'm
you're
sorry about
talking
that.
about?
So for the bill attached to the resolution, just on page 2, where did it go?
Okay, wait,
there's
we're not on Bill 6. We're going back to,
Yeah, the resolution bill
Okay.
for the LUO.
well, can we do those amendments at the Planning Commission? Or would you rather do it here? But go ahead.
I see. I'm sorry. Yeah, you're right. We could address it at the Planning Commission. And so under Bill 6, though, I think it has similar language that under the contents of a notice of violation, that we are required to include a statement of the actions that are necessary to be corrected.
If you could, if I'm looking at Bill 6, CD1, what page are you looking at?
Page 3, B6.
B6, okay. A statement of actions that are necessary to correct the violation. What's your suggestion?
Just to delete it.
Delete?
Bill 6.
Okay.
Oh, and then, yes, I mean, this is, I think I need to speak to staff about this, but I think there was a change from, on page 1, and then in other areas, page 1, subsection A, deleting erect and replacing it with install.
Okay, which is what the bill currently does. We delete, you'd rather have erect as opposed to install?
Yes.
Okay, keep erect, get rid of install. Okay, what else?
And that was it.
Okay, so only those two changes, Chair. One on page 1 and one on page 3, and then I think we're good. Otherwise, you're in support of
Yes.
Bill 6? Terrific. Thank you.
Okay, members, any other questions for the director? The chair has just one question for Director Apuno, and this is in regards to Resolution 24-141. Pursuant to the revised ordinance of Honolulu, sections 2-24.3, subsection B, subsection 1, on May 17th of 2024 by the Council Communication 157 of 2024, the department was notified of the introduction of Resolution 24-141 proposing an amendment to the land use ordinance. Does the department have the information and documents needed to process this proposed land use ordinance?
Yes.
Yes, okay, great. Thank you. So at this point in time, members, we have gone into the testimony of our administration, which is the director. Are there any further questions for Director Apuna at this point in time? Okay, if not, we'll now proceed with the remote testimony. Madam Clerk, do we have any remote testifiers?
Yes, Chair, we have one standing by.
Okay. Oh, it's Miss Young again. Okay, please proceed, Miss Young.
Aloha, Angela Melody Young testifying on behalf of CARES, wishing to comment. And so I'm not trying to be critical, but I'm just trying to point to a specific example because it was what we talked about last time for the LUO discussion when I was present at the discussion. So, and to kind of summarize the concern, right? The LUO is a robust discussion about development standards as well as other regulations. And I'm worried about public use, for example, the public use and the civic use and the institutional use of facilities, right? And the standards for it, because the final copy of the document is 435 pages. And how do we expect the community to disseminate and to process all this information without an educational process? And then it just gets served a violation when people may not even know that they are in violation of something. For example, when farmers are to meet in a meeting facility and there were a lot of like restrictions on meeting facilities on ag land.
Okay, Ms. Young, thank you very much for your testimony in support of resolution or comments. Okay, got it.
Can you ask which measure?
Ms. Young, which measure did you testify on? Resolution 24-141 or Bill 6 of 2024?
The resolution, but I can testify for the bill also.
Okay, got it. Thank you very much. So clarify it for the committee and the chair. Madam Clerk, are there any further remote testimony?
Chair, there are none.
Okay. Madam Clerk, is there any in-person testimony?
Chair, there are none.
Okay. Members, we are now, excuse me, is there anyone else here in the chamber who would like to testify? If there is none, okay. Members, we are in discussion. Yes, Chair.
Thank you so much. Real quick, I'd like to ask you to incorporate the changes requested by DPP on Bill 6. Seems like those two are fairly easy to do. That's it. Thank you.
Okay. Okay, that's Chair's recommendation. All right. At this point, at this time, the Chair would like to recommend that Resolution 24-141 be reported out for adoption first. Okay, any discussion, objections, or reservations? Hearing none, so ordered. It has been adopted. Moving on to recommendation Bill 6 of 2024. The Chair would like to recommend that Bill 6 of 2024 be amended to the committee draft 1 posted on the agenda. And the amendments proposed by the Director of Department of Planning and Permitting in regards to page 1. Is that correct? Yep, page 1. Chair, can you go back and highlight the two amendments that was proposed by the director on page 1 and page 3, if I stand corrected?
Yes, I just put my notes away.
Okay.
On page 1, subsection A.
Yep. You want to restore it with erect.
Correct.
All right.
Erect instead of install.
Okay.
And then on page 3, subsection B, subsection 6, simply delete it.
Okay. Yeah. Okay, let's go on page 3 first. Okay, the staff is asking me, can we also, on subsection B of page 1. If you want to go back, when I say go back, revise it back to erect rather than install also, to be consistent with subsection A.
That makes sense.
Okay. Chair Waters and Director Apuna, is it possible that we can just blanket all of the wording in regards to the install be deleted and erect be restored? So
Yeah.
on
Yes.
page 1A, subsection A, we're going back to erect. Subsection B, we're going back to erect. And on page 4C, where if a building or structure or portion thereof is erected, we're going to go back to erected rather than installed.
Yes. And then,
Correct.
is that in the OU? Okay, and then, sorry, additionally, there's also other references to providing the correction for the violation on page 3 and page 12 that we would also like deleted.
Could you restate what you just stated?
Sure, so on
Page
page
3.
of Bill 6,
Yes.
page 3,
Yes.
subsection B6, and then page 12, sorry, subsection 6 at the top. So actually just two areas that's located.
That 2 sections you want us to delete?
Yes, please.
Okay. Any concerns? Okay. Okay. Thank you.
Thank you.
Oh, we're on page 7 of the agenda. Councilmember Wire. Okay, so we have how many proposed amendments? 3 of the erect, restored. Oh, yeah, okay. Chair Waters, we're going to ask for now, the chair going to make the members for discussion on what the amendments are proposed by the department. So any discussion? Any objections or reservations? Hearing none, the bill has been amended to a committee draft 1. The chair then recommends that Bill 6 of 2024, committee draft 1, be reported out for passage on 3rd reading. Any discussions, objections, or reservations? Hearing none, so ordered. This measure has been adopted. Moving on to agenda number 4, Bill 52 of 2023, Committee Draft 1. This bill relates to large dwellings. Members, the Committee Draft 1 version of this bill amends the administrative enforcement provisions in Land Use Ordinance Article 2 to provide for enhanced fines for land use ordinance violations relating to large detached dwellings. The enhanced fines will be up to $25,000 initial fine and up to $10,000 per day for each day the violation persists. At this time, we have the director once more, Apuna, to testify.
Thank you, Chair. We are supportive of this CD1. Thank you.
Okay. Members, any questions? Yes, please.
Thank you. Thank you,
Councilmember
Director. I have a question with regard to your authority to demolish ask for the demolishment of the house for noncompliance. So my question is, number one, do you have that authority? And if you have that authority, could you walk me through the notice of violation and notice of order process? And what I'm trying to get at is I'd like to know if the current authority that you may have is sufficient or whether the relevant ordinance needs to be modified to give you stronger tools to be able to have an alternative in addition to penalties to demolish a house
Thank
or
you.
require demolishment of the house.
Thank you, Council Member. So I don't have the ordinance doesn't provide me a direct authority to just say, okay, demolish that house. It would depend on the specific circumstances of that property. So it's more that if the structure does not meet the code requirements and it, say, exceeds requirements, it's too large, by requiring them to correct that and come within the proper code, the result is that they would likely have to demolish part or all of the house, depending on what the requirements are. So in that sense, so for one of the more popular monster homes, we understand that the Board of Appeals determined that their structure and the plans were not correct and that it was too large, and basically in order to come back into conformance with the monster homes requirements, that they're going to have to size it down to some extent. So that's basically how they would be required to remove portions or part of their development.
Okay, that's with regard to the structures. With regard to the penalties, the financial penalties, what if they keep on accumulating it after X amount of days, let's say 90 days, and they still do not pay you? Would you, in that case, have the authority to require, to be able to demolish? I mean, require demolishment?
No, we would probably move towards lien and then putting a hold on their registration, their motor vehicle registration and license. And then from there, if they still don't, then we could potentially move for foreclosure.
Okay, thank you for that. So I guess my question, going back to what I originally stated, would you like to have stronger authority to be able to have that tool at your disposal as opposed to what you've described to me now?
I think that would require some legal review because it does, border on whether there's takings involved. I think what we are doing currently is we're ensuring that people are complying with the law, and when they go outside of that, that's when we require them to come in.
I understand it. I just have to share that communities are fed up. They're disgusted because they see blatant violations with no cure. And they feel that these bad neighbors flaunt it to everyone, disrupt neighborhoods, and have no respect for residential communities. Thank you.
Thank you.
Okay, any further questions for the director? If there is no further questions, we'll now proceed with remote testimony. Madam Clerk, do we have any remote testifiers?
Chair, there are none.
Thank you very much. Is there anyone else standing by at this point in time, Chair, Madam Clerk?
Chair, there are none.
Thank you. Now let's move into in-person testimony. We'll now proceed with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay. If there anyone else in the council chamber who would like to testify, please come forward to the podium and state your name for the record. Okay. There are none. Let's move on. Members, we are in discussion in regards to Bill 52 of 2023. Okay, Council Member.
I just wanted to thank
Yes.
you. I just wanted to thank the administration as well as Chair Waters for introducing this. Strongly support the Kailua neighborhood adopted a resolution supporting this measure, and as you can see in my line of questioning, while I'm pleased, I want to make sure that DPP does its best within its current authorities to pursue violators. And I'm always interested in looking for stiffer penalties. So fully support.
Okay, thank you very much. Councilmember DeSantos San.
Thank you, Chair. I want to thank Vice Chair Kiana for bringing up the question of demolition, because I think that this is something that, frankly, we've danced around a little bit. I think we've seen a lot of egregious violators continue to persist, and we keep being told that DPP has the power to compel violators to follow the law. we keep being told that, we can fine them, and yet we have discovered that, many of these fines are uncollected. And so I think that adding further penalties, including demolition, may be a good idea. I don't know if, right now where this bill stands, this is the right vehicle to do so. But I think that we do need to make a point that we are serious about making sure that people follow the rules, and not just give lip service to the DPP inspectors who show up.
Thank you very much. Your point is very much well taken. Any further discussion on the measure at this point in time? Okay, if not, the chair recommends that Bill 52, 2024, Committee Draft 1 be reported out for passage on third reading. Any discussion, objections, or reservations? Hearing none, so ordered. Moving on to agenda number 5. This bill relates to registration requirements for bed and breakfast homes and transient vacation units. Members, we have posted on the agenda a proposed Committee Draft 2 version of the bill. For your information, a summary of the amendments is listed on the agenda. The Committee Draft 2 version of the bill, which I've proposed, would amend the initial and renewal registration requirements to provide that the letter from the applicable homeowners association or apartment owners association confirming that the B&B or TVU unit is permitted must be dated no more than 1 year prior to the date of the application, instead of the 6 months. If you recall, this was Councilmember Tupola's suggestion at our last zoning meeting earlier in May. So at this point, would you like to say a few words, Councilwoman Tupola?
Thank you so much, Chair, and thank you to DPP. I think, we've been going back and forth in just small minor edits, so thank you for including those, and I think it's fair and it'll also make it easier. Anything that can make it easier for them to get the things that they require upon request. Thank you, Chair.
Okay. At this point in time, let's move on to the administration. Director Apuna.
Thank you, Chair. For this proposed CD2, we still do request that the initial registration documents be provided upon request rather than having them be provided as part of the submittal. Also on, I think it's page 2, subsection F, with regard to the letter from the homeowners association, we would like there to not be a year, that it be within a year, dated within a year, because the associations, they are non-governmental, they're private, and I think the pace with which or when they update, it may be difficult for some of the applicants to get a letter that will satisfy that requirement. So I know we discussed last time how we might want to require the homeowners association to provide information to DPP, but we're just trying to think of how we can make it easier for the applicants to provide that information. So I just want to put that out there. And then lastly, one request we have is to remove that when there's a change in owner or operator, that they notify DPP to remove that there's a change in operator, because we deal directly with the owner only, not the operator. The operator could be separate and different than the owner. So those are our 3 recommendations or comments. Thank you.
Councilmember Tupola, please.
Director, thanks for being here. I agree. I think we all agreed, and maybe we can work on that draft about the by request. We did all kind of think that that was the best way, so that you're not carrying a bulk load of documents that you guys might not have storage for and that might be outdated. Secondly, I think we had extended it from the 6 months to the year, right? So what is your suggestion exactly? And we also talked about just receiving their bylaws by request, because it would be stated in there whether or not they were allowed. And so that might be easier than obtaining a letter. But what is your desire here for that portion?
So I think a letter that just states, and we don't require a date.
I see.
Yeah, that would be probably the simplest. I think, if it comes down to it and we're really unsure and we're getting questions, we can directly ask that association, but we don't want to put too many restrictions that makes it hard for them to even register or renew.
Yeah, I hear you. So basically, just a letter stating that they're required to do it, but not, we don't, I guess to your point, we don't need to put the bylaws if you're just able to contact them in when and if there is doubt, right?
Right.
And then the last one, as far as the owner, I understand that part because true, the operator is actually could be a platform. It could be various different things. So just interfacing with the owner would be probably the easiest if there was a change. So hopefully, we can work on this, still working through a small edit. So thank you, Chair. Thank you, Director.
Thank you.
Any further questions for the director? Chair Waters, please.
Thank you very much. I understand why you're asking that the requirements be by request, but just hypothetically, if we were to proceed with that scenario, and when you requested the documents and they were not able to comply, what would happen next?
I think they could be subject to violation. I believe the provision is for any not complying with the STR sections that you could be subject to violation as normally you would for a STR violation.
So what would that violation be? And what would the fine be? I mean, the violation would be what exactly?
And that's a good question.
And then secondly, would we be creating this expectation similar to, those folks who had been renting their short-term rentals for more than or less than 90 days? Are we creating this expectation that we've given them the permit, and then if they don't actually have the documents, how do we? I mean, I just want to avoid a lawsuit down the line, right? Saying that, well, we got the permit, DPP gave us the permit, and then, or registration, and then all of a sudden we take it away.
You mean specifically to the 90 days or less, or just in general? Because just in general, our belief is that because they're in a certain zoning, it's almost by right that they can if they register, they're entitled to the STR. But if we have issues or complaints and we need to investigate, then we would ask for that information, and they would need to provide it.
So those by right, the bed and breakfast homes operating under a valid non-conforming use certificate, also a transit vacation rental, pursuant to 21-4.110-2, or a transient vacation unit operating under a valid non-conforming use certificate, pursuant to 21-4.110-1, need only comply with subsection 3. So we are already giving those folks a break on the registration. So what group are we actually targeting here? Right? If you're zoned, you're in a resort area, I'd imagine, so you're fine. You got a non-conforming use certificate, so you're fine. But what about all those people who sued the city, right? Who said that under the federal lawsuit, right? They had a right to do it. Those are the people I think we need to make sure they register properly.
So I think that's going to be part of our next step of establishing rules to deal with those that believe that they have a STR right. So, and then they would come under, if they did qualify, yes, they can register, but there needs to be, I guess, the process involved to see which ones could be determined as valid STR applicants, and then other processes, because if we deny that, what's the appeal process? So I think you're right, there's that other set because of the lawsuit, et cetera, that we will address through administrative rulemaking and potentially some ordinance changes.
Well, I guess that's what I'm saying. We're putting within this bill those requirements, and we want it to be done up front rather than just by request, especially for that gap group that we're talking about as a result of that lawsuit in federal court.
I think what this registration requirement does is it makes sure that everyone, just broadly, everyone that qualifies for an STR should be registered. I think before it was by right, as far as just by right and no to registration, but the ordinance 22.7, the intention was whoever's going to run an STR, you need to register. And we're saying you pay the registration fee and you qualify as far as where it's located. But upon request, if we need to look at those additional documents that you should have at any given time, that we will look at those too.
Okay, I can see that for, having functional smoke detectors and occupancy limits and stuff like that. But the initial requirement, of the valid general excise tax license, valid TAT license, you're saying that as well should be done by request?
Yes, I think we want to make sure that they're operating. I mean, that's not necessarily fully under our jurisdiction, but we believe that they should be operating legally as that type of business. And sometimes we coordinate with those other agencies to determine violations, et cetera. So I think it's good that they have all of that readily available.
When you're in the DMV and you have to transfer ownership of a car, they make you get a valid safety check to make sure that you have insurance on the car, that it's operating in a safe manner. This is kind of the same thing. If we require this stuff up front, you solve a lot of problems down the line.
I can see that. We're still requiring it up front. We just won't say that you submit it. You should have it. Like, that's the requirement, that you should have all these things, but subject to, upon request, we will ask for it. So I think you're right. It's a little different than the DMV, but I think they still are required to have those things all up to date and done. Yeah.
Okay. Thank you.
Councilmember Tupolo, followed by DeSantos Tan.
Thank you, Chair, for those questions. Definitely valid. I think we definitely went through a lot of that and had inquiries about whether or not we should just get it right up front too. But I think to just clarify, the way I read this, from what I understand, is if you guys request it and they don't furnish it, that they can't re-register. I thought that's what it was. Because isn't it an annual registration? Yeah, I think just for clarity, because we're all very firm on not supporting any illegal vacation rentals, is like if any of that's out of compliance, every year when you re-register, that as I read it, that you wouldn't be able to re-register because you'd be out of compliance with DPP. Is that correct?
Right. Those documents should be updated annually with the re-registration.
Yeah, I just wanted to clarify that because I don't want it to be like the Monster Home where it's a forever fine that doesn't go anywhere. Basically, if you don't comply, you can't continue. So I think that's actually firmer than a fine. Thank you, Chair.
Okay, Councilmember DeSantos Tan.
Thank you, Chair. With regard to this question about a change of ownership or any of the other issues that would require a new registration, does that make it a new TVU or a new bed and breakfast? And I ask this because, if I recall correctly, the injunction in the Hillstra case only pertained to 30 to 89-day home rentals in existence on that date. And so if there's a transfer in ownership, does that trigger a new rental, or is it simply the existence of an old one? And I realize Cora is probably going to come up here and tell us that this is an executive session question, and I don't want to go into executive session, but I think that this is an important thing for us to understand at some point, because the state adopted that new Senate bill. We're likely perhaps to do something here. So I just want to make sure that with respect to those which are covered by the Hillstra case, that they're covered. And then if anyone were to create a new registration, what are their obligations?
Yeah, thank you. Again, I think it is going to be a process for us to go through rulemaking, working with CORE, and potentially changing the ordinance to specifically address those under the Hillstra case. But yeah, I defer to Core.
Mr. Pang, would you like to say a few words since it's been deferred to you?
Dwayne Pang, Deputy Corporation Counsel. The initial registration requirements were for, this is prior to the Hillstra lawsuit. So technically, they were the registration requirements for the legal ones that council designated in the resort areas and others. The Hillstra case, because of state law, didn't allow us to phase out the residential uses. So there is a question, and I have to go back and look to see whether the Hillstra court decision may or may not allow us to require them to register. So we're going to have to look at that. And then the other question is, as you mentioned, is that what is council and the city going to do with respect to the most recent state law that was passed? So now allowing us to adopt ordinances to phase out what we wanted to phase out under the original bill. So I think that that's where we're not there yet, and I think that that's why the director is indicating we have to work together and adopt the rules. So what Bill 53 is doing is just amending what the registration is requirements that for those that were you guys deemed legal, I guess, several years ago. So this does not change who can have a short-term rental.
Okay, thank you.
Was your question answered? Okay, Councilmember Wire.
Thank you, Chair. Director Apuna, I just wanted to make sure I was following. When you're talking about allowing by request and working with other agencies, is it that, for example, you can do a search and find out like someone's tax status, or can you tell me a little bit more about what you meant by that in terms of not needing it to be all required up front?
Yeah, I think that it's more just an administrative issue. For, say, there's about approximately 1,000 registered currently, or about that. And so we would go through 1,000 applications and have to look at all of this long list of documentation. And I think part of it is that it's by right. So it's kind of like a good faith that they have all that stuff. They still need to pay and qualify within that certain designated area. But it's also, I think our efforts are better directed at the enforcement side. So when we get RFIs, et cetera, we can concentrate on, okay, now we need all your documentation. And then it seems more efficient for us to use our resources towards that.
Towards enforcement.
Yes. And then there's other agencies, whether it's DOE tax, et cetera, and the TAT, et cetera. I think we do often communicate whether these things are correct, but I think that comes on the enforcement side when we're having issues with the STR, et cetera.
Okay, yeah. I appreciate that. And then just the second question, I know we talked about it last time, but you had mentioned, so I know they need the letter, previously the bylaws, but then in terms of a revocation, what do you need for that? Like another letter from a board, or could it just be a phone call, or what would be the mechanism, I guess, if the...
Yeah, maybe an official letter from the association say we don't allow STRs. That would be sufficient. But we could figure out what would make sense in this specific case. Yeah.
Okay, I appreciate that, and I know that part of that's already in the law, but I think just generally I always have concerns when we're trying to pull the city into private contracts, because I have so many HOAs and AOAs that beef at different levels, and whether it's someone's permit getting pulled or giving a permit, I just don't want the city open to litigation. Yeah.
Thank you.
Yeah. Mahalo, Chair.
Okay, any further questions for the director? The chair has a couple of questions. Director Apuna, what makes this draft so cumbersome that you folks can't adopt it?
So we did,
This is to
oh,
protect the department. The draft that we have is to protect the department and the city and county of Honolulu. That's all it is. But tell me, if you're in opposition to certain portions of it, why? Since, is it too much of a work? Is it too, encumbering for the employees? It's better to me to have a draft that is very specific to the point, whereby everybody knows, rather than, a piecemeal type of legislation. And the point is that for the chair, will 9 members of the council, 8 members of the council remember this particular day, this morning, when we have these type of discussions? Either or, as far as the private landowner versus the operator. I don't know, but you can explain to me why it is so cumbersome for the department to just say we adopt committee draft 2.
so since the original ordinance was adopted and implemented, I think it was October 2022, and then we started taking registrations. So we've been through this process with the applicants, and we think even hearing the applicants and what we're dealing with, the requirement to have all these documents at registration, it seems excessive and maybe unnecessary. So therefore, we would like it to be by request that they provide the information to DPP, rather than it becomes a duty on both sides to submit it and for the department to go through every one of these documents. So that's why we don't like
Okay.
that part.
Well, if you look at the testimony that has been submitted on this particular measure, 24 plus testifiers have stated in strong support of the committee draft 2. So this probably, the 24 testifiers may be associations, maybe private landowners, maybe operators. That's why I don't understand what's the objections to the committee draft 2.
Well, I think maybe it's those that support it, they feel like it's a safety blanket that, if I put everything in and I get my registration, I'm good to go. But it's the same thing if we require all these documents, but upon request. So I don't think there's much difference, except that the department isn't burdened with having to go through and make sure everything is correct, when we could use that time and energy to focus on the illegal ones, the really problematic ones. And so I'm not sure either why there's pushback to say upon request. It's still required, and if you don't have it when we ask for it, that might be a problem too. So I'm not sure either why there's, yeah.
Okay. Any other thoughts on Councilmember Tupola, please?
Yeah, I think, Chair, you're right. And I think, Director, there could be a way we work this, because to be honest, I think what a lot of the testifiers are saying is they have their documents, they want to prove that they're legal, they want to do things above board, and that's why they're like, yes, let's do this. So I think just per your department, because you guys have a website, that you guys can indicate on there how to interface with them on that, because I think that the ironing out is a little bit minimal, and I think definitely with the small amount of people you're working with, that it could possibly work out administratively, if that works out. Because again, I think that's what the overall perception is of people in my community that are just trying to register legally and make sure that they're above board. Thank you, Chair.
Thank you very much. Okay. Would your division chief like to say a few words? Or the individual who is in charge of this particular program?
Yeah, we'll have Lena provide some comments.
Okay, please proceed, Lena.
Good morning, council members. Lena Pomswan, DPP staff planner. We do support the general intent of the bill to make it easier on the people who want to register and be legal. For us, as the staff actually processing it, we have one staff member that has processed over 2,000 applications right? So each application can take hours, depending on the information provided, can take days. So, upon request would be something that would be beneficial for both the applicant and for the department itself. I think in terms of the testimony that was submitted, I think they just do agree that this bill does make it easier and it's more helpful for them. We want to make it even more easier on them for that part, and that's why we're wanting to put upon request.
Okay, Lena, your point is very much well taken. But for me, it's a question of Lena, Lena. For me, you can come up to the podium.
Oh, I'm sorry. Could you repeat that?
No, I just wanted to share with you my thoughts. Was that this is a journey that's just beginning, and I'd rather have something concrete as far as the committee draft too, because it flushes out everything that everybody should know. At what point in time will there be a request made?
The request would be made if there's a RFI, or request for investigation, that occurs. So in general, based on the current ordinance, the STRs are already allowed just based on zoning itself, right? So that's what makes it legal versus illegal. The registration documents are just more supportive documents for us to review. I wasn't here during the passing of that ordinance, so I don't know, what the background is of why certain things are required. But it seems to be like the department is usually the person or managing what other requirements that could be going to other departments, like taxation and stuff like that.
I think the requirements are based upon the premise that with more of these requirements, it just shows the legitimacy of that particular operation. To have a TAT that is a short-term vacation rental or a B&B, the general excise tax, all of these were supporting the department's cause in seeing that these illegal TVUs may be, having to comply with all of these requirements. And it's a template for me that I'll probably have to do it if I was a private landowner. I'll have to do it when I do my income taxes, all of the income that you make. So I bring this up to the committee as far as your discussion on what you folks would like to see to make it easier for the department, or just try to comply as much as you can with the work that one individual would have to go through. Yeah. Okay. Thank you very much, Nina. Okay, Madam Clerk, are there any other remote testimony?
Yes, Chair, we have some standing by.
Okay. We have Mr. Michael Hay. Michael, please.
Yes. All right. Aloha, Chair Say, Vice Chair, and committee members. The Oahu Short-Term Rental Alliance, or OSTRA, as you all know us by, represents the thousands of residents who own, manage, and work within the legal mid and short-term rental industry, and we strongly support Bill 53. And we truly thank all of you for all of the efforts you do to work hard at City Council. We also support the chair's amendment, as well as any other amendments that ease the process for both DPP and applicants. Having been one of the above board people who own an STR at Turtle Bay, I've gone through the process twice now. The first time was long and arduous, the second time better, and we look forward to it being even simplified more for DPP and applicants. So we really appreciate the collaborative work of the zoning chair, his staff, the DPP, to propose the streamlining and new renewal process. The change will lessen the workload for DPP, encouraging more TVUs to register and this legislation is a positive step forward to demonstrate the county's commitment to working alongside the community for the benefit for all. Mahalo.
Thank you very much. Members, any questions for Mr. Michael Hay? If not, thank you very much. Moving on, let's move on to the next remote testifier. Ms. Angela Young.
Aloha, Angela Melody Young, testifying on behalf of CARES, just wishing to comment. I was just curious if Office of Economic Revitalization was consulted to talk about business law and economic influence. Because like business law can be used properly as a tool to guide policy, right? Instead of law being used to like sue people, because I think that's abusive. And there should be a balance, right? For example, I think that with restrictive business laws, unintentional effects happen, such as restricting small businesses, like B&Bs. In this setting, and the result is dominant corporations can use policies to favor themselves over small businesses, which can lead to small businesses being driven out of business and the economic vitality of communities being damaged. And also from the antitrust laws from the Department of Justice, it says that when there are no laws to check corporate power and there are no laws to encourage small businesses on entrepreneurship, this results in unfair competition in the business sector. So, for example, hotels versus
Ms. Young, your time is expired.
I'm summarizing.
Thank you very much for your comments.
So, basically, the hotels can dominate instead of Airbnb.
Thank you very much for your comments at this point. Members, any questions for Ms. Young? If not, okay. Madam Clerk, are there any more remote testifiers?
Chair, there are none.
Okay, let's proceed on with the in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay, members, we are now in discussion. Any discussion? If not, okay. Moving on, the chair would like to recommend that Bill 53 of 2023 of Committee Draft 1 be amended to the Committee Draft 2, posted on the agenda. Any discussion, objections, or reservations? Hearing none, the bill has been amended to a Committee Draft 2. The chair then recommends that Bill 53 of 2023, Committee Draft 2, be reported out for passage on third reading. Any discussion, objections, or reservations? Hearing none, so ordered. Let's proceed on to agenda number 6, Bill 10 of 2024. This bill relates to building permits. Members, we have listed to the agenda 2 proposed Committee Draft 1 versions of the Bill 1. Bill 10, excuse me. One submitted by Councilmember Tupola and the other I submitted. For your information, summaries of the amendments are listed on the agenda, and at this point in time, I will defer to Councilmember Tupola to explain her Committee Draft 1.
Thank you, Chair. So last committee hearing, we did discuss the section that suggests that if there are resubmissions, that there would be a fee. After speaking with the director, she described the resubmission fee as applying to people who possibly were licensed or knew better and were really creating more work for DPP. So my suggestion was to write in there that this would not apply to people who are first-time applicants or people who really needed help navigating through the process, as many people are still stuck in the DPP process. And I hear what she's saying. So this draft that I proposed, which is kind of old now, was suggesting that we strike it. And we had all suggested that instead of striking it, that we come up with language that suggests that if the person is licensed, has applied for multiple permits, and is still requiring DPP to give them edits, that there would then be a fee applied. We did email the director and didn't hear back on what she would like for the verbiage there, but that was the intent with my CD. Thank you, Chair.
Okay, members. At this point in time, the chair's proposed amendments are as follows. It retains the language providing that except to correct a violation on a zoning lot, the DPP will not accept or process a building permit application if the property owner has any outstanding fines, payable, or liens in favor of the city. We also reinstates the 2 affidavit requirements, affirming that a majority of property owners concur with a building's demolition and affirming compliance with certain restrictive covenants because the deletion of these provisions do not fall within the bill's purpose clause, as required in Charter Section 3-202. And we note that DPP may introduce a separate bill to delete these affidavit requirements. And 3, we provide an exception for owner builders authorized by Hawaii Revised Statute 444-2.5 from being subject to an additional plan review fees upon resubmittal of an application that initially failed to include necessary information. At this point in time, we have Director Apuna.
Thank you, Chair. We are supportive of the latest draft, and we appreciate Councilmember Tupola's suggestions. I think it is important to provide some specific standards, like that they are licensed or other factors, so that we can weed out the ones that are bad actors versus those that are maybe new to the process, et cetera. So I think this is a good start, and it might also require some rulemaking, which I know the bill provides for, so that we can really figure out what those standards are upon which one we would charge an additional fee. So other than that, we have a couple of just small comments. On page 1 of the bill, where house under subsection B2, house is stricken, and we'd like to keep that in because there might be multiple structures on the lot or street address. And then on page 2 at the top, paragraph 6, we would ask that specialty not be stricken from that first sentence. And other than that, I'm available for any questions.
Okay, any questions for the director? Okay, if not, we'll follow up when we make this discussion. We will now proceed with remote testimony. Madam Clerk, do we have any remote testifiers?
Chair, there are none.
Thank you. Is there anyone else standing by remotely?
Chair, there are none.
Thank you. We'll now proceed with in-person testimony. Madam Clerk, do we have any in-person testifiers?
Chair, there are none.
Okay. Is there anyone else in the council chamber who would like to testify? There's no one. Okay. Members, we are in discussion.
Chair.
Yes, Councilmember Tupola.
Yeah, I support your draft, and thank you for putting in the admin rules. I think that the minutia of deciding who gets fines can definitely be handled by the department through admin rules. So that suffices the concerns that I had, and I thank you for incorporating that.
Okay, thank you. Any other discussion that members have at this point in time in regards to the measure that is before us? Okay, well, Director Apuna, would you please come back up to the podium and share with the members the amendments that you'd like us to consider at this point? On page 1. Director Apuna, would you please come on up and state the amendments that you have that you'd like us to consider?
Yes, thank you. So on page 1, paragraph B2, to not strike out house and in the second line.
Okay. House. Okay, next.
And then on page 2 at the top, paragraph 6, the first line, to not strike out specialty.
So that particular section would be something like this then. Provide the name, license number, and address of all specialty contractors and subcontractors. Correct? On page 2.
And house and street address.
Yeah, that's on, hold on page 1 first then.
Yes.
So on page 1, members, subsection B2, describe the land on which the proposed work will be done by reference to the property tax map key number and house and street address, if one has been assigned. Okay. Any questions for those proposed amendments? Councilmember Tyler DeSantos Tam.
Thank you, Chair. So just to clarify, with regard to striking out the word specialty or retaining the word specialty, right now,
yes.
as it stands, an applicant needs to provide the name and license of all contractors involved in the project. That would involve the GC and all the other subcontractors under that definition. So what you're proposing is to retain the word specialty and include the words and subcontractors. What happens with identifying the general contractor who's going to be on site?
You work under the general.
Right, because if we retain the word specialty contractors and then add some contractors, we're still excluding the GC from being identified. And I think that's maybe the most important part.
Yeah, I mean, we could add "and general contractor" under paragraph 6. But maybe paragraph 7 covers it because it says for each contractor and subcontractor.
I just want to make sure that they're consistent.
Right, so it should be general contractor, subcontractors, and any specialty contractors.
Vice Chair, did you get your question answered? Okay. Any questions, members, for the director? Okay, at this point in time, as far as the urgency of the measure, I would like to recommend, members, that there's been a lot of discussion on the circumstances that would justify imposing additional building permit review fees, whether there should be an exception for owner builders, whether it should generally apply after 1 cycle, or whether it should apply after 3 cycles. I'd like to recommend that we take this under consideration to determine what may be the appropriate action. And the chair would like to recommend that action on Bill 10 be postponed to a time and date to be determined by the committee chair. And we'll address the concerns once more in the restatement of specialty versus deletion of specialty. General contractors, which is not reflected also. And we'll see how the language that we can come up with. So the chair would like to recommend that action on Bill 10 be postponed to a time and date to be determined by the committee chair. Any discussion, objections, or reservations? Hearing none, so ordered. Thank you. Okay, members, moving on to agendas number 7 and 8, which we will be taking together. First, we have Bill 3 of 2024, Committee Draft 1. This bill relates to incentives for the construction of affordable rental housing. Remember, this bill will only relates to the post-construction grants. The proposed pre-construction financing is being addressed under a separate bill, which is Bill 31, 2024, which is also being considered under the next agenda item. Okay, among the other things the committee draft 1 would do is that we retain the $10 million aggregate limit on general fund monies and provide that the maximum amount of funds available per fiscal year is limited to the amount appropriated for post-construction grants in each fiscal year's executive operating budget and program. We increased the grant amount to $12,000, previously $9,000 per unit, rented to households earning more than 60% to the 100% EMI, and we increased the grant amount to $18,000, previously $15,000 per unit, rented to households earning 60% below the AMI. Provide that to be eligible for the post-construction grants, the dwelling unit must be a minimum of 300 square feet in size. Dwelling units may be smaller, but will not be eligible for the post-construction grant. Revised Ordinance of Honolulu, Chapter 29, relating to affordable housing requirements, defines micro units as a dwelling unit that is 300 square foot or less in size. Note for the record that affordable rental housing projects under Revised Ordinance of Honolulu, Chapter 32, are intended to primarily target the development of workforce housing. And 4, add penalty provisions to allow for the recapture of the total post-construction grant amount together with a penalty in the form of interest at 10% per annum if the project fails to satisfy any of the requirements of the Revised Ordinance Honolulu Chapter 32. That's for Bill 3. Bill 31, this bill relates to a pre-construction financing for affordable rental housing. Members, as mentioned, this bill was introduced to separate the pre-construction financing for affordable rental housing from post-construction grants, which are the subject of the previous Bill 6 of 2024. Bill 31 of 2024 would require that the Budget and Fiscal Services Director to adopt rules to implement pre-construction financing because it involves a much more complex process than post-construction grants. Designate the source of funding for the pre-construction grants as the Affordable Housing Fund, and provide that the maximum amount of funds available per fiscal year is limited to the amount appropriated for pre-construction grants in each fiscal year's executive capital budget and program. Designating a different source of funding other than the general fund monies was to address the concern that if the same pot of general fund monies as post-construction grant is used, since owners seeking pre-construction financing are able to submit applications earlier upon issuance of a building permit, then owners seeking the post-construction grants upon issuance of a certificate of occupancy in any given fiscal year, pre-construction financing may exhaust available monies before post-construction grants are eligible to apply. 3, we provide for a financing amount of $25,000 per unit rented to households earning 60% or below of the AMI, because the use of the Affordable Housing Fund monies is limited by charter to providing affordable rental housing to persons earning 60% or less of the AMI. This way, pre-construction financing could subsidize housing for lower income groups, which are more difficult to pencil out. 4, we provide that to be eligible for pre-construction financing, the dwelling unit must be a minimum of 300 square feet in size. Dwelling units may be smaller, but will not be eligible for pre-construction financing. 5, limit the use of pre-construction finance money to paying prevailing wages in compliance with the Hawaii Revised Statute, Chapter 104. 6, require the execution of a written pre-construction financing agreement between the city and the owner of the project and set forth terms that must be included in the agreement. And 7, add a penalty provision to allow for the recapture of the total pre-construction grant amount, together with a penalty in the form of interest at 10% per annum if the project fails to satisfy any of the requirements of the Revised Ordinance of Honolulu Chapter 32, or if the owner breaches any of the terms of the pre-construction financing agreement, including if the pre-construction financing monies are used or expended for improper purposes. Members, we have posted on the agenda a proposed committee draft 1 version of the bill that was submitted by Councilmember Kiaina. For your information, a summary of the amendments is listed on the agenda. At this time, I will now defer to Councilmember Kiaina to explain her committee draft 1.
Thank you, Chair. Members, my amendment, this would be an amendment to Bill 31. It removes the provision that identifies the Affordable Housing Fund as the funding source for the pre-construction grants, and it retains the provision to limit funding for developments for households earning 60 AMI or below, and it provides that the aggregate of general funds used for both pre- and post-construction grants does not exceed 10 million. And the reason that I would like to remove the Affordable Housing Fund is because currently there's only about 8 million a year that is appropriated, and my concern is that Bill 1 or Bill 7 pre-construction grants could easily wipe out this fund, which is the only funds that are regularly appropriated for rental housing for households earning 60 AMI or below, and that of 60-year affordability requirement. I also wanted to note that this fund has supported many projects, including in particular projects that prioritize funding for homeless families in many of our districts. I also do want to note that during our discussions on the fiscal 2025 budget, whereby we fully funded DPP's request for $5 million, I specifically asked the DPP director because there were concerns by some members that the funds were not being utilized, and I asked her that if the pre-construction grants bill moved forward, wouldn't she believe that it will, it would be able to utilize these funds, because we wanted to make sure you spent the $5 million, and her answer was in the affirmative. So I just wanted to, I wanted my colleagues to understand why I'm doing this. Number one, we have funding available in the budget for both pre-construction and post-construction. And again, second, I'm deeply concerned about narrowly tailoring it to the Affordable Housing Fund, which is already used for other projects and is direly needed. Thank you.
Thank you very much. Your point is very much well taken. Members, at this point in time, let's hear from the Director of Department of Planning and Permitting, Director Apuna.
Thank you, Chair. We're supportive of both Bill 3 and 31. I think there's some concerns about the 300 square foot requirement, but I've seen testimony and heard how, this is an issue about the construction financing and how it all works out, and that it doesn't necessarily mean that it'll be just micro units. So I defer to Office of Housing and others who can explain how that would work. So that's all I have, and I'm available for any questions.
Okay, thank you very much, Director Apuna. The Executive Director of the Office of Housing, Ms. Denise Iseri Matsubara.
Aloha and good morning, Chair and Zoning Committee. Denise Iseri Matsubara, Office of Housing. So you have our written testimony. We strongly support this bill, the CD1 version of the bill. And now, more than ever, it's critical for the city to find ways to facilitate the delivery of housing. This increase in the bump in the grant is exactly what is needed. The administration's position, as Director Apuna has said, is that we have heard from developers, there's concern about the minimum size, and that the administration's position is to let the market dictate that. I'm happy to stand by for any questions. Thank you.
Okay. Any questions for the Executive Director? Ms. Matsubara, please.
Thank you. This may be a DLM question rather than an Office of Housing question, but it's my understanding that the city, within its affordable housing portfolio, has a number of units that are below 300 square feet for a variety of reasons. At Citron Street, Mohala, all of those units are below 300 square feet. At Pi'ikoi Street, the studios and one bedrooms are below 300 square feet. And at Winston-Halle, in my district, there are units at 273 square feet that are dedicated to people in Housing First or HUD-VASH. Are you aware of any city policy that restricts the city units to be more than 300 square feet?
I would have to defer to DPP. I don't know what the minimum is in the housing code or building code, but I would defer to DPP on that. And as for the square footage of the rental housing portfolio within the city, it's definitely a DLM question. Thank you.
Okay. Councilmember Wire.
Mahalo, Chair. And I share Vice Chair's sentiments too, understanding that I think we do want to spend more on housing than what we're currently doing. And so dipping into the Affordable Housing Fund, I think would just reduce our ability to increase units. But Director, I wanted to just ask if you could walk us through maybe a little bit of the financing in terms of what's available to 60% and below versus those approaching 100%. Understanding that if we're keeping the pre-construction tied to Affordable Housing Fund, then of course it would be limited by the charter. But if we say, to return to the original Envision grant program that's currently in the budget, I'm just curious of the implications or how it could be used if we increased maybe the AMI allowance or what's allowed under the pre-construction program.
So let me see if I understand your question correctly. Denise Matsubara, Office of Housing. The question is on Bill 3, changing the funding source to back to...
Bill 31.
Oh, the question is on Bill 31. Okay.
And I'll just restate, because I think initially I was just mentioning how I support Vice Chair's amendment and taking it off of the Affordable Housing Fund. I think obviously if we left it on the Affordable Housing Fund, we'd be reducing funds available and then also limiting it to the type of AMI that the projects could go to. And so I'm just wondering if there's any perceived benefit of making the pre-construction grant program available to higher AMI projects.
I see. Thank you for the clarity. So with regards to Bill 31, the change in the funding source off of the Affordable Housing Fund and back to the original general fund source for Chapter 32, I think is logical. The target AMI group, as zoning chair has mentioned, is workforce housing, the 80 to 100% AMI. When Bill 7 was first crafted to allow for a 60% AMI and below market, you really need the help of the LIHTC program, Rental Housing Revolving Fund Subsidy, and also private activity bonds. Because to my knowledge, I don't think that any projects have come up with that target in mind, because these simply can't, it's not feasible to build. It won't cover your mortgage. So that target group really does need a whole lot of government subsidy to the tune of about $150,000 per unit just on rental housing revolving funds, and then more money from the low-income housing tax credit, as well as the private activity bonds can consume about $230,000 per unit. So yeah, anything below 60% AMI requires very heavy subsidy to make it pencil.
Yeah, Mahalo, Director. And Chair, I had a question for Director Puna, but I'll defer if we want to stick with Denise.
Any questions for Executive Director Matsubara? Okay, for both, why don't you continue on with Director Apuna?
Yeah, I just, thank you, Chair. Wanted to maybe get a little bit more info on exactly what micro units are, or the smaller units. Do you have any insight on that?
Micro units, so there is, and I can't remember
or
what
efficiency units, I think, or is that the same
there's
thing?
like I can't recall. I'd have to ask staff.
Sorry to put the pressure on.
Sorry, but so I think under the housing code there are like minimum requirements for and it's less than 300 square feet.
Okay.
Yeah.
I think is it like something like 120?
I think it's more than that, like I think it's like less than 200, but more than 120.
Okay.
Sorry.
No, I appreciate that. And but then I think there's other, like under Chapter 29, I think there are also minimums for those projects as well.
Right, I'm not sure. I'm sorry, I don't have those details, but I can check.
No, I appreciate that. And I just asked because I think that the size is going to be a point of contention as the conversation goes forward. So thank you, Director. Mahalo, Chair.
Any questions for the director? Okay. What the chair would like to do at this point in time is that we're going to go through with Bill 3. Oh, excuse me. Let's proceed on to public testimony. Madam. Okay, we will now proceed to public testimony, and there will be for both Bill 3 and Bill 31. Please identify which measure you're testifying on. At this point in time, let's proceed with the remote testimony. Madam Clerk?
Yes, Chair, we have one standing by.
Okay. Ms. Young? Unmute yourself, please.
Am I unmuted? I can't unmute. I don't have the power to do that. Okay, so I'm testifying. I'm wishing to comment. And so these are just my thoughts for pre-construction. Like, where is this money going, and what mechanism in the law determines which developer?
Ms. Young,
Yes?
I apologize. You're on the wrong measure at this point in time. We are with the post-construction.
Oh, post-construction. Okay, so for post-construction.
Are you just testifying on the pre-construction? That's all.
Which one do you want me to do first?
You're the testifier.
Okay, so.
Okay, identify which measure you're testifying on.
I'm going to testify for the pre-construction because it makes more sense to start from the pre-building process and then go to the post-building process.
Okay.
Okay. So, is there consideration of disparity for home ownership? Because, okay, now we're on to the next one because my time is up. So I'll just testify for the post-construction bill. So, again, these are just my thoughts. I'm just curious also, if there are other people who want to respond and what their thoughts are. And so what this means with like disparities is economic disparities, the conditions of being equal because of racial disparity, which race someone is from determines inequitable home ownership, and also wealth disparity, right? So income plays a major role in home ownership and wealth accumulation. And there is a well-documented persistence of income inequality by race, a key factor contributing to the home ownership gap. And so with racial disparity of home ownership and health and income disparity, I'm just curious, what is the mechanism in the law that determines where the money is going and if there will be more funding for those who are suffering from inequitable home ownership, right? So for example, those who work with Hawaii Public Housing Authority serves marginalized vulnerable populations as veterans, disabled, low-income communities. Those developers, are they prioritized to get more funding because you need more of those low-income housing projects or like luxury projects? Okay.
Ms. Young, your time is up, and thank you very much for your comments.
Okay.
Okay. Members, let's proceed on. Madam Clerk, are there any further remote testifiers?
Chair, there are none.
Thank you very much. Let's move on to the in-person testifiers. Madam Clerk?
Yes, Chair, we have some standing by.
Okay. Let's proceed to Mr. Gina Thielen.
Aloha, Chair, Vice Chair, members of the committee. My name is Gina Thielen. I'm here to testify in support of Bill 3 and 31, with some very important caveats. Starting with, both bills contain a requirement of a minimum of 300 square feet per unit. This requirement is not only unwarranted, but it's actually detrimental to the original mission of Bill 7 and the subsequent grant that was established with Bill 1. Neither of these bills ever required a minimum square footage. In fact, they capped a maximum square footage. So what we're doing is we're essentially punishing people that are following the intent of the original law by building units that those most vulnerable in our community need the most. As an example, some of you have had the opportunity to walk through one of our projects at Ernest Street and seen sub 300 square foot units that are fully occupied by people at very low AMI levels. So I think that that's a negative in both bills. In addition, in Bill 31, I would just like to comment that we support the version put forth by Councilmember Kia Aina, and would say that in addition, we would request that the AMI level be raised to 80%. The reason for this is that most Bill 7 developers are all targeting 80% AMI with their buildings. It's the highest level that we can achieve where we are getting enough return on investment that it supports the project, but it's also benefiting the people that we are most able to with very minimal support from the government. On a final note, if I can take the time, I think I would get 1 minute for each bill. Thank you. I would just like to bring up the idea that has been discussed about pre-construction grants exhausting the $10 million. It would require us to build 400 units to exhaust the $10 million at $25,000 unit. I would put it to this body that if you can get 400 affordable apartments for $10 million, that's a heck of a good investment. With that concludes my testimony. I'm available for any questions.
Okay, any questions for Ms. Thielen? Councilmember DeSantos Tam.
Thank you. Gina, with regard to the 10 million that you mentioned, is that all of that state, city money, or is any part of that from the state? Do you know?
My understanding is that the state has pledged an additional 5 million on top of that 10 million, so the fund would go up to 15 million. Frankly, I'm a little confused on where the 5 million is at this point, but that's my understanding is what the commitment has been made.
So theoretically, we could have either more units than the 400 you described if we were to exhaust all of it, or if, you know, in some other scenario, it's partly the state, so it's not entirely city money. I mean, either way, that's a good deal for the city, right?
Absolutely. I mean, I'm not familiar off the top of my head, but the housing director just mentioned the fact that some of the subsidized units that are being built with government funds are costing upwards of $200,000 per unit to the government. So again, I would go back to a $25,000 investment. And if we do factor in that additional 5 million, you're talking 600 units. That would be a fantastic investment and worthy of the council considering funding with additional money.
Okay, Councilmember Kia Aina.
Thank you. No questions, but for Chair, I just want to say that I am open to the increase in the AMI. Initially, when I offered my amendment, it was relating to the Affordable Housing Fund, which requires the 60 AMI. And so my intent was not to alter the AMI level for the for Bill 7 projects. I understand that the underlying measure had that, and so I guess I just want to let you know that I am open to reverting it back to the AMI that currently exists for Bill 17 projects. Thank you.
Okay, no, why don't you bring it up when we have our discussion on the measures? Okay, members, any other questions for Ms. Thielen? So, Mr. Thielen, I'm going to go right down. Oh, excuse me. So you're in support of Bill 3 and Bill 31. The only objections is the 200 square foot minimum.
Thank you, Chair. Yes, that's the objection that both bills have in common, is they both contain that. In addition, Bill 31, I was commenting on the request to raise the AMI.
Got it. Okay, thank you. Later on. Yeah, later on. Okay. Ms. Roseanne Freitas? Chris, there you go.
Oh, I got that part. Good morning and thank you. I'm Roseanne Freitas, CEO with the Building Industry Association of Hawaii. And I'm here to represent our industry. On Bill 3, we have written testimony that you should have, and we stand by that written testimony. And then on Bill 31, we do support the amendment by Councilmember Kia Aina. Thank you. If you have any questions.
Any questions for Ms. Freitas? Okay, thank you very much. From the BIA. Chris Delaney, PRP. Yeah, I got it.
Aloha Chair and Council members, Chris Delaney with Pacific Resource Partnership. We're in support of Bill 3 and 31. However, we do recommend and request that the minimum of 300 square feet in size be removed from the legislation. First of all, you know, the original bill, as discussed, didn't have it in there, and then also it makes it very difficult, if not impossible, to build these types of projects on small square footage of lots with the height limitations, et cetera, to actually make it pencil out with, you know, this kind of a minimum requirement of 300 square feet. And my understanding is the International Building Code, as was mentioned, allows for smaller types of units above 120 square feet in size. So we respectfully request that limitation be removed, or that minimum requirement of 300 square feet be removed. With Bill 31, we're in strong support of the proposed CD1 provided by Councilmember Kia Aina. And thank you.
Okay, thank you very much, Mr. Delaney. Any questions for Mr. Delaney? Okay, Councilmember Cordero.
Thank you. Chris? Hi, I have clarifications. If you said Councilmember Kia Aina's CD1, but did you hear that she's open to putting it back to the 80%? Are you okay with that too?
Oh, yes, absolutely.
Okay,
Yeah.
thank you.
Thank you.
Okay, members, any other questions? If not, let's proceed on. Mr. Pani Malitoga, the third.
Aloha Chair, members of the committee, Pani Malitoga III, Deputy Political Director for Operating Engineers, Local 3, in support of Bill 3 CD1, as well as what my colleague has just mentioned about repealing the square footage minimum. But yes, we support the bill and the amendments. Thank you.
Thank you very much. Any questions for Mr. Malitoga? If not, thank you very much. Oh, Mr. Nathaniel Kitty.
Chair and members, Nathaniel Kinney, Hawaii Regional Council of Carpenters, like the two testifiers before me, in support of the amendment offered by Councilmember Kia Aina, and then also removing the square footage amendment. On a side note, perhaps it's not cold enough in here. We could just jack up the I mean, it's, I don't know, maybe is it me or?
Mr. Kinney, I believe it must be you. Thank you. Okay, Mr. Emmanuel Zuckerman.
Hello, Chair, members of the committee. Emmanuel Ziwakalam here on behalf of the laborers, Local 368. I think the temperature is perfect. Additionally, we're in support of Bill 3 as well as removing the per square foot requirement, and we support the amended version. Thank you.
Thank you very much. Are there any further testifiers in person who are here this morning? If not, members, any questions for the testifiers at this point in time? Okay, it's maybe who should represent our trades? Or would it be Mr. Thielen? The idea, why don't you come on up, Mr. Thielen? Don't worry. Okay, first and foremost, the 300 square foot was an idea and concept that is part of the state's Hawaii Vice statutes. And that's how the staff and I researched it. The idea was more that we provide more units for our working people, units that I think will be much more comfortable than micro units. I don't have the answers as far as penciling the financing of it, but what would you say consists of a 300 square foot unit for a couple, a married couple? What does it look like? 300 square foot unit, a one bedroom, bathroom, no living room but a kitchen. I don't know. I don't live in a 300 square foot unit, but I bring this up for the edification of the members and the general public out there. Don't you feel that we are obligated to give these residents who are in the 80% AMI and below a better living condition? Okay, go right ahead, Mr. Thielen.
Thank you for the question, Chair. I guess I would like to answer on two fronts, if I could. First off, included in my testimony on Bill 3, I included a sort of a two-page analysis on the square footage issue. And in it, I included information about our future projects that we have planned before any of these sizes were required. I'm trying to find it in the two-page testimony. I guess what I'll just summarize it essentially is that we, as market-driven developers, are designing a wide range of units. What our analysis has found is that smaller lots with less unit count do not support certain amenities, specifically elevators. And for us, we're trying to keep our buildings at 3 stories since they're walk-ups. Our belief is that the long-term viability of renting out a 4th floor, as well as the added cost of constructing a 4th floor, are counterproductive and discriminatory towards these smaller lots, smaller unit buildings. As a different example, one of our biggest projects, which is made up of 90 units that's currently in the permitting process, is entirely made up of 80 one-bedroom units and 10 two-bedroom units. Our one-bedroom units are in excess of 350 square feet, and our two-bedroom units are nearly 700 square feet. But because this building has 90 units, it can support actually 2 elevators in the construction costs. And we have 5 floors over a podium, so it's a very different type of construction that we're looking at in that situation. By and large, the vast majority of our units are in excess of 300 square feet. The other part of that question that you asked that I believe needs to be addressed is the demand for units that are smaller than 300 square feet. And I'd like to share a story about one of the people that moved into our building on Ernest Street with you all. We had someone that was brought in by a case manager from a social welfare service that has a housing voucher. And when they were given the keys to their unit and shown the inside, they asked, "How many people do I have to share this with?" And when they were told, "No one, this is all yours," he began to cry. So there is a huge demand in Honolulu for these units that are less than 300 square feet. If there wasn't, we would have a vacancy rate, and we have none.
Okay, any questions for Ms. Thielen? Please, Councilmember Water.
Thank you, Chair. And I just had a question coming back to the AMI. And so you had mentioned earlier increasing. I'm just kind of curious your thoughts on if there needs to even be a distinction between pre and post, or if it could just maybe be a 60 and below category and a 60 to 100 category, or if there's a need to differentiate. I mean, do you have any thoughts on that?
Yes, thank you for the question. I guess I'll relate my thoughts specifically to Bill 7 projects because that's what I'm familiar with. Bill 7 was created with the ability to have a sliding scale on rent. You can actually charge rents as high as 100% AMI, but there's benefits once you are below 80% AMI. And to the best of my knowledge, all other developers that I have spoken with that are working in this space, everybody is targeting 80% AMI with all their projects. If you introduce a benefit package that's below that, that's 60% AMI, it will go unused by Bill 7 developers because we simply can't pencil out the cost of construction at that level of rent.
Okay, mahalo for that. Thank you, Chair.
Okay, members, any questions for Ms. Thielen? Thank you very much, Ms. Thielen. Any other questions for any of the in-person testifiers? If not, the question then we can move on, members, is that we're going to ask the department and the executive director of the Office of Housing that for Bill 3, both of you can come on up to the podium and you can, share with us the first and foremost, the committee draft 1. Are you folks both in agreement of the 10 million aggregate limit on the general fund monies?
Denise
Are you folks in agreement with the 10 million aggregate fund?
So,
yes, the draft, committee draft. I'm just trying to get a clarification in regards to the chair's amendments. As far as if you folks are in support, okay. If not, why? That's all it is. So for the first one, as I said earlier, the committee draft 1 of the first amendment was to retain the $10 million aggregate general fund. You folks are all in agreement. Okay. Number 2, we're increasing the grant amount to $12,000. Previously, $9,000 per unit rented to households earning more than 60% and up to 100% of the AMI. Are you folks in agreement? Okay.
we are.
And increases the grant amount to $18,000, previously $15,000 per unit, rented to households earning 60% or below of the AMI. Okay. Number 3, provided to be eligible for the post-construction grants, the dwelling unit must be a minimum of 300 square feet in size. Dwelling units may be smaller, but will not be eligible for a post-construction grant. Revised ordinance of Chapter 29 relating to affordable housing requirements define micro-units as a dwelling unit that is 300 square foot or less in size. Note that affordable rental housing projects under revised ordinance of Honolulu Chapter 32 are intended to primarily target the development of workforce housing. Okay, that's where the disagreement occurs in regards to the 300 square foot. What would you folks want to see? Going back to the original Bill 7? By units? Oh. Okay. Yes, Ms. Matsubara.
So Denise Matsubara, Office of Housing, in conferring with Director Puna, I think this is a decision that the council's going to have to make.
Okay, got it.
The administration has heard from the development community. I think it's a really tough question as to what this program is about. Is it about workforce housing, or is it about transitional housing for the homeless? Is it about communal housing? What are we trying to support? What does this particular program trying to do? Because there are other programs for other target populations. I think the council needs to decide what is the target market for this.
Okay, because for number 3, it was converting a grant program to a unit basis instead of a square foot, right? What are your thoughts? A unit basis now, before it was a square footage.
I think it simplifies the implementation a bit, but then you run into this square footage, so.
Okay, so there's some difficulties with that. And for, how would you want to address the issue in regards to, this is 2020, 5 years in the making, right? Was it 2019? Bill 7? Okay, and how much have we encumbered at this point in time? Encumbered meaning the dollar amount that we had appropriated in the past 2 years, 3 years. Or how much has been released?
Our recollection is 150,000 for the one Pu'uhue Place project.
Okay. And how many more are outstanding that we could? The reason why I'm posing this question, if the post grants are not being a successful program, should we consider just putting it into the pre-construction? I don't know. You folks are the executors and administrators. Okay, hold on. Councilmember Kiaina.
Well, I'm actually open to both. So they are utilizing the same pot of funds, but I'm quite confident, as all the hearings shared, that on the pre-construction front, you're going to see an uptick. So I would hate for them to be one pot for one and one pot for the other. Let them compete, but at the end of the day, just so we continue to move these projects forward, it's a win-win situation for all involved. And I think the developers understand probably what is probably more useful right now, which would be the pre-construction grants, which is why a lot of people are looking forward to moving this bill forward.
Well, okay, your point is very much well taken, primarily because, yeah, the pre-construction grant is a grant that is tied into the overall financial plan of a development. The key point for me would be that I would like to have some future obligation for all 9 members of the council. When there is a shortfall in the fund, a priority should be for this fund. If not, let's not talk about it. If you exhaust the 10 million within the next year and a half, you folks come back and this council would have to be obligated to support this fund. That's all I'm saying, because it's a pay-as-you-go. First comes, first serve. And are we willing to, obligate ourselves in the out years, whereby the general public voted against a city charter amendment in regards to affordable housing? Okay, because it's a great commitment that we are making, and that's why I'm posing all of these tough questions. Are we going to support this particular program if funds are not available? And there's an obligation by the city to fund these grants, pre and post. And what would it take if I have a declaration or intent to say to DPP that we are building it, so this is what the obligation will be? What I'm getting at is sometimes we appropriate funds whereby people see that pot of gold and they'll just go and get it. But my point is that will we have the courage later on to replenish that fund with all of the other competing interests that we have outstanding? So that's why I try to figure out a way that we could try to address it. Personally, for myself, I apologize to all of you that Bill 7 has morphed from its original intent, which was basically post-construction. And I don't know if it's going to be an agreement as far as for the pre-construction funds program as a grant or a stipend or another adjective that we'll use in the financing world. I wish Director Kawano was here, because the 300 square foot I got it from the Department of Budget and Fiscal Services as a standard. ROH, but also he stated, okay. Okay. Any other questions that you folks may have at this point in time?
Council Chair, can I just add a couple?
Yes, please, Ms.
Bits of
Matsubara.
information? So we know that the program has moved slowly. It got hit by COVID, and then developers had to change their designs, plans as they tried to figure out this program. And then my understanding is the Board of Water Supply rules changed and some other things changed. So that's part of the reason why it was a slow adoption. But I just got to tell you, in talking to some of these developers, there's 1, 2, 3, 4, at least 5 projects in the pipe that are going to be close to completion for a total of almost close to 200 units, not counting the Pu'uhue place of 25 units. And that's going to account for at least $2 million based on the 12,000 per unit post grant. So it's in the pipeline. I think it's really important that the city, because this is its only by right housing program that the city has right now. And if we really want to support housing, we want to keep the pipeline going, but we want to do it in the right manner. So, you know, we're happy to work with council. We want to find the right fit. But the whole point is, let's not give up on this by right housing program. I think it's important for the rental housing community. We just need to really clarify what is our target market here.
Thank you. Ms. Matsubara, I would say that for the council, the target group is all, from the 60% AMI and below to the top 140. And we've been trying to address more of the gap group. That's the objective, I think, of the council this past 3.5 years, as far as I've been in this position. And that's where I'm trying to focus, where can we get the best buck of the dollar? But please, any other questions that you folks, yeah.
Chair, I just want to make sure with regard to your recommendations, you are also recommending the reversion back to 80 to 100 AMI or 80 AMI?
It has to go back to that.
Okay,
right?
okay, I just wanted to make sure. And just to make a comment on your concerns, they, you know, I know why you have them, because, you know, this was intended as a pilot project, which is why we have the cap, but I don't think any of us would have been seeking to fully fund it if we didn't want to give it a chance. So I think with this two-prong approach for both post and pre-construction, I do believe that it's going to breathe a new life into the ongoing projects. And so for me, if successful, and they pass that 10 million, I'm clearly going to be interested in seeing how we can continue the success of this program. And let me just bring up a little bit a side note about why I've been critical about the city CDBG program, because that's $8 million. We're looking for various sources of funding. If they were to do a better job with a prudent, affordable housing and homelessness programs, which I don't believe they do a good job, that is a slew of funding that can help make a dent as well, not just the Affordable Housing Fund and the Bill 7, Bill 1 project. So I just wanted to make a comment, because we're always looking for money.
Yeah.
And here we have a pot, and a lot of it is going to other projects that have nothing to do with affordable housing or homelessness, which is eligible for CDBG funds.
Okay. Any further questions? So can we move? Oh, Councilmember Wire, please.
Just a quick one, Chair, and I can direct it to admin if more appropriate, but I wasn't sure if based off the Vice Chair's comments, if we had moved on to also Bill 31. So
Yes, we're gonna
if
move
we're
on to
doing
Bill 30.
2 tiers, I was just curious what the grant, if there's any ideas for an appropriate grant amount for a second tier, or if that's still to be determined.
I think that would be to be determined at this
Okay.
point. I haven't.
Anyone that we should direct that to, or I don't know if there's any input, but I'll leave that up to Chair then.
For the pre-construction, let's go on Bill 30. Any other questions, members, on Bill 3 first, before we move on to Bill 31? Okay. For the members, would you, for the first provision, require the BFS director to adopt rules to implement pre-construction financing because it involves a more complex process than post-construction grants? Would you want to set a deadline in the promulgation of these rules? I don't want to come back next year and say, oh, we didn't do the rules, so we're not doing anything. I just want you folks, I'm soliciting your input because it is important. Executive Director Matsubara, you think you could get BFS to promulgate the rules if it is adopted for the pre-construction grants or stipends or whatever we may call it? Yes, Director Apuno.
Sorry, I missed the question, but as far as the rules?
Yeah, by BFS.
Oh, by BFS?
Yes.
Okay, so I can't speak for BFS.
Right, that's why I'm saying, do you think if we put in a provision that it be done, like, for example, this being May 22nd today, May 22nd, that it be done by May 22nd, 2025. So all of us can see what's the status report. Councilmember Cordero, please.
Thank you, Chair. I understand that, when we do implement this, that we also are funding the project so that, we normally ask for updates, or not normally, but we can ask for updates, whether it be 30, 60, or 90 days even, because if we are planning it to be considered for financing in the next budget next year, we would love to have those rules available for us, right?
Right. That's why we're putting the gun to their head. Can they do it within that period of time of 1 year, the promulgation of rules? Or shall we be once more flexible and, if we're going to move...
I'm good with 90 days. Oh, sorry. You have to recognize me.
Okay, I just bring that up. And the source of... Oh, Matt, please. Councilmember Wire.
Thank you, Chair. I should know this, but I was going to ask Director, so the process for getting the funds out is on a rolling basis, or is it an RFP, or what would the standard process be?
Yeah, we were just discussing that. I think we have to do some underwriting for the pre-construction. So that might require, rather than rules, a professional that can do that, or contracting out someone to do that. And actually, we're curious if some of the funding could be used towards a position or contract to administer that part of the process.
Okay, I appreciate that insight. And I only bring that up because I think my reading is that they may promulgate rules. So since it's not a shall, I'm not sure what the intention of the committee and council is, but I do think regular updates are good.
Okay. Okay, so let's move on to number 2. So we are not going to address the Affordable Housing Funds. Am I correct? For number 2 on Bill 31.
You're not going to limit it to the Affordable Housing Fund.
Right.
That's correct.
Right. That's correct. Okay.
But you're not going to limit the 60 AMI for the Affordable Housing Fund to Bill 7 projects. Yeah.
Correct. Okay. Okay, and then number 3, we did it with a increase of amount $25,000 per unit rented to households earning 60% or below AMI. We're going to take out that 60%. Okay. Moving on to number 4. We're taking out number 4, which is provide that eligible pre-construction financing, the 20 unit, must be a minimum of 300. Taking that out also. So no standard. Yeah. So basically, no standards now, gang. No standard square footage based on the units. Now, I'm just looking out for the general public at large. Okay, number 5, limit the use of pre-construction financing monies to paying prevailing wages. Okay. require the execution of a written pre-construction financing agreement between the city and the owner of the project and set forth terms that must be included in the agreement. Are you folks in agreement with that? Tyler, are you okay? Chair Waters? Councilwoman Kiana, are you okay with that, the written pre-construction financing agreement? Maybe there's no need for rules on that, okay? But folks are aware. And 7, we had the penalty provisions if they don't meet their obligation. Other than that, members, any other questions that you folks may have? Yes, Councilmember Wire.
Thank you, Chair. And, you know, I'd invite DPP Director to chime in, but just because you had mentioned just the no minimum requirement, I mean, I'm definitely open to the discussion on the point, but I think my assumption is that it would still be bound by the requirements of our current housing code and building code in terms of all the habitability standards that apply to the community. And so I don't know if there's insight as to why 300 is the limit in other areas like Chapter 29, but that's kind of where I'm at. And so, you know, definitely open to hearing more from folks, but I'm just going forward with the assumption that we're going to be complying with they'll be complying with the law as it's currently written.
Yeah. Well, I hope so. Councilmember DeSantos Tam, please.
Thank you, Chair. I just have a question about, this was not covered in the amendments, so this is a new question. In 32-5.2C3, this is the next section after where it talked about the 60% MI and below and 300 square feet. So this section says pre-construction financing may only be used for purposes of paying prevailing wages to every laborer and mechanic performing work, ... I understand the intent behind this, and of course I think it's valiant, but I just want to make sure that it's not written in such a way that any dollar that the city gives has to be, the developer has to somehow hold on to that, and then the developer then has to use those dollars directly to pay a laborer or mechanic, because normally the developer would pay a general contractor. The general contractor sort of divvies it up, and so I don't want to make it so difficult in the execution. So I just want to make sure that this is something that BFS and the developers can actually execute on, that money goes to those laborers and mechanics, or maybe we make it clear that it goes to the general contractor for the purposes of paying them.
Okay, why don't
I think we can work on this in a CD2.
Yeah. Okay. Any other thoughts, members, at this point? Okay. So at this point in time, members, with your indulgence, the chair would like to recommend that we've had a lot of discussion on the eligibility requirements for the post-construction grants, that the dwelling unit be 300 square foot, that will be deleted. Perhaps a sliding scale grant amount based on the unit size or number of bedrooms should be used, okay. Whether the same grant amount should apply to all units regardless of size. I'd like to recommend that we take this all under consideration to determine what may be appropriate, especially since post-construction grants are already available under current ROH Chapter 32, Article 3. So at this point in time, why don't we postpone the Bill 3 for further discussion? And we'll probably pick it up next month with a final draft to clean it up on behalf of the committee and for the administration. Okay? So the chair just recommends that action on Bill 3 be postponed to a time and date to be determined by the committee chair. Are there any discussions, objections, or reservations? Hearing none, so ordered. Also for Bill 31, the chair will recommend that we also to postpone this one and work on it further, but have the committee going back to this particular measure next month. So it's postponed to time certain? No, it's going to be the next committee zoning hearing that we have. So that everybody's, how would you say it, in the train of thought of understanding Bill 3, Bill 31, Bill 1, Bill 7, Bill 6, etc. of the past. So 7 and 1 and 6 were passed already. The original, the money that was in Bill 1 that the mayor had, and then Bill 6. So 33 and 31 postponed to work on it further, and then we get it back next month as a hearing. So it's not postponed, time uncertain, but it's postponed till the next zoning committee hearing. Yeah. Okay, so if there's any discussion, any objections or reservations, hearing none, so ordered. So if I'm gonna ask that we work on something, yeah, and shared with you folks prior, with the director and the executive director and also the director of BFS at this point in time, Budget and Fiscal Services. Okay, let's proceed on. Members, last on the agenda, agenda item number 9, Bill 65. This bill relates to the adoption of the State Building Code. Members, we have posted on the agenda 2 amendment forms, Council Communication 83 of 2024, proposed by Council Member DeSantis Tam, and Council Communication 15 of 155, that I had proposed. I will defer to Council DeSantis Tam to explain his amendments, then I will explain the amendments I'm proposing. Council Member.
Thank you, Chair. And this is for Bill 65, correct?
Yes.
So my proposal is fairly simple. It deals with medical trailers, which there's some ambiguity as to whether they're buildings or not, and thus subject to building permits. So for these mobile medical trailers, perhaps a CT scan machine, this would exempt them from being considered a building for the purposes of this bill.
Okay. Oh, for me, members, the amendments to Bill 65 that is being proposed in Council Committee Report, Council Communication 155 of 2024 are those recommended by the DPP in Departmental Communication 294 of 2024, which was in response to the edits suggested by the American Institute of Architects and Departmental Communication 298, which included additional amendments suggested by DPP. The 2 controversial items that we have discussed in the past by the committee on February 2nd of 2024 relate to the windborne debris and tsunami loading provisions. As recommended by the DPP, those topics have been addressed in Council Communication 115 of 2024 as follows. Windborne debris. With the deletes table R301.2.1 and section R301.2.1, which would retain the definition of windborne debris regions that is included in the 2018 State Building and Residential Codes, with a wind speed trigger of 130 miles per hour. According to DPP, this will allow the State Building Code Council to address this highly controversial issue during further code amendments. 2, the other major issue was the tsunami loading. We are going to retain the criteria currently in the committee draft 1 that tsunami loading would apply to risk category areas of 2, 3, and 5 buildings. At this point in time, we call upon Director Apuna. 4, 2, 3, 4 buildings. Okay, Director Apuna.
Thank you, Chair. We're supportive of the current CD1, and we're available for any questions. Thank you.
Okay. We will now proceed with remote testimony. Madam Clerk, do we have any remote testifiers?
Yes, Chair, we have one standing by.
Okay, and that is who do we have? Gary Chalk.
Gary Chalk.
Gary Chalk, please, Mr. Chalk. Please proceed, Mr. Chalk.
Okay. Thank you, Zoning Committee Chair Say. I'm speaking in favor of the tsunami design provisions in Bill 65 CD1, retaining the requirements for risk category 2 buildings 90 feet and taller. If I understand it correctly, the 155 amendments do not affect that. And if that's correct, then I support the bill. On the windborne debris region, I also support the retaining the 130 miles per hour criteria as stated in the state building code for consistency with all the other counties, and that is justified technically in the hurricane experience we've had during Hurricane Eva and Iniki. Thank you very much.
Thank you very much, Mr. Chalk. Any questions for the testifier? If not, then we proceed on to the other testifier. Mr. Ian Robinson.
Good morning, Chair Say and committee members. I'm Ian Robertson, Arthur Chu, Professor of Structural Engineering at the University of Hawaii. Dr. Chu, who unfortunately passed away in 2006, would be very happy to see the inclusion of the 130 mile per hour as the defining limit for windborne debris. So if that's my understanding of what is in CC 155, I fully support that. I also fully support the design of taller risk category 2 buildings as required by Department of Emergency Management for vertical evacuation, particularly in Waikiki, downtown, and Kaka'ako. Designing those for tsunami is essential, therefore, because we're calling them vertical evacuation refuge for tsunamis. So I'm fully supportive of those two measures if they remain in this bill. Thank you very much.
Okay, any questions for Mr. Robinson? Next, we have Miss Gina Thielen.
Aloha, Chair, Vice Chair, members of the committee. I am here for this bill in my capacity as the volunteer chair of the Codes Committee for the Building Industry Association of Hawaii. My name is Gina Thielen, and I am strongly opposed to Bill 65 as it is currently drafted, and would request that this be deferred to a date to be determined. My reason for requesting this is twofold. First off, BIA Hawaii has been very proactively engaged with the administration and the council on these code amendments. We began work on the IBC and IRC amendments starting back in 2022. As of the date of this hearing, we have not even been given an opportunity to see this bill in its full format. The only thing that was posted online was the proposed amendments. We believe, in all fairness, it's important that we have a chance to review the bill in its totality and be able to make comments based on that. The second reason for opposing this is that as part of the former deputy director work, Jiro Samada, we had come to a compromise on the tsunami. BIA Hawaii has always opposed the tsunami provisions in the code in totality, but we agreed not to oppose it on risk category 3 and 4 buildings as long as risk category 2 buildings were exempted. Our understanding was that this was the agreement that would be incorporated in this bill, and it has not been. So for those reasons, I would request a deferment today. Thank you.
Okay, any questions for Ms. Thielen? If not, thank you very much. Madam Clerk, are there any further in-person testifiers?
Chair, there are none.
Oh, Mr. Arakawa.
Okay, good morning. Good morning, Chair, Vice Chair, and Chair Waters. Dave Arakawa on behalf of the Land Use Research Foundation of Hawaii. We agree with Gina's testimony of the BIA on this bill. We support DPP's original comments in the communication sent to the council on December 28th, 2023. It's a letter and it includes two specific amendments, both on the windborne debris and on the tsunami loading. And the reason for this is that those two amendments were put in there by DPP after extensive review of the engineers on both sides. And I think you may have another letter dated December 15th from the Structural Engineers Association of Hawaii, where they say that they would support further study of those two issues. They do not support the current version, but they do support further study of those issues. And couple points. This morning we confirmed that the windborne debris provision would increase the cost of a single-family home by $15,000 to $30,000 per single-family home, and we can get you that in writing. And these are bids, actual construction bids, so they're not guess numbers, they're actual construction bids. And for the tsunami, the cost would be $5,000 per condo unit. And this is a project that has already been built. Okay, so to increase affordable housing by that much. We'd like to thank DPP, the zoning chair and members, council staff, and council services for meeting with the industry and talking story with us and going over this bill. We would respectfully request that this council either adopt DPP's proposed amendments in their December 20th, 2024 letter, which you received on December 28th, 2023, or respectfully request a deferral of this matter so we could work on it further. Thank you very much.
Thank you very much. Any questions for the testifier, Mr. Arakawa? If there is no further questions for Mr. Arakawa, may we proceed on. Madam Clerk, are there any more in-person testimony?
Chair, there are none.
Okay, members. At this point in time, yeah. Okay, one more testifier online. Ms. Young, please. Ms. Young, please.
Aloha. Someone is controlling the mute and unmute thing. Okay, so I'm going to be testifying, wishing to comment. And so an estimated 489 cities within the Pacific states of Alaska, California, Hawaii, Oregon, and Washington are susceptible to tsunamis. And beyond preparing for evacuation and emergency response, communities can reduce tsunami risk by modifying land use planning and development approval practices. Although planning for tsunamis is not a top priority for most coastal communities, relatively small efforts to plan for this hazard can significantly assist with community safety. And so this is from a report from NOAA, the National Oceanic Atmospheric Agency, and it's a national tsunami hazard mitigation program plan, and it's put together by planning people from the county of Hawaii and Kauai. And so I think it'd be really interesting to read the science to why there should be tsunami-proof buildings. And also because the tsunami-proof building is purposefully designed as a building to withstand and to survive the forces of tsunami waves and extreme storm surges.
Ms. Young, thank you very much.
Okay.
Okay, thank you. Okay, members, any questions for the testifier? If not, Madam Clerk, are there any more in-person testifiers or online testifiers?
Chair, there are none.
Okay, thank you. At this point in time, members, let's proceed on. We are now in discussion. Any discussion, members, at this point on Bill 65 of 2023? Chair Waters.
Thank you so much, and thank you for your hard work on this measure. You know, I met with Deputy Director Jiro Sumata a few weeks ago, and he did a lot of work on this bill, including studying with the stakeholders, discussion, and then negotiating. So I concur with what Gina Thielen and Mr. Arakawa are saying, that and support going back to DPP's original version.
Okay, members, any other questions or discussion that we may have? If not, okay, Councilmember Santos Sam.
Thank you. I want to also mahalo DPP as well as BIA and the other stakeholders for working together on this. It's obviously a very complicated bill. I think one of the major sticking points is the question of the tsunami construction standards. And, in previous hearings, I think I was definitely open to hearing all sides of this, but something that recently happened that's come to my attention, especially in my district is the additional hurricane insurance requirements for condos and other buildings, and that's really driving up the cost of maintenance fees, driving up the cost of financing, getting mortgages, and it's making it much more difficult for people to be able to afford to stay in their own homes. And so it makes me concerned that if we were to impose additional requirements on certain buildings for tsunami preparedness, we would continue to drive up the cost of housing for local people. And that's something that I think we need to be very mindful of. And that's the lens that I'd be looking at these tsunami provisions through.
Any other question? Okay, Council Member Kiaino, followed by Wire.
Thank you. I know that in the previous hearings, I expressed concerns over the tsunami provisions to keep it in, and then I'll leave it to Councilmember Wire on the wind. And I need to tell you that I think I was narrowly focused to certain corridors in Waikiki and Kaka'ako, and I don't think I understood fully the potential implications on affordable housing projects. So I actually didn't. And so having said that, I have been meeting with, I appreciate the stakeholders on both sides, but I have been meeting, lots of meetings, both with DPP and other stakeholders. And so I'm concerned about that. And I guess I have changed my position and am open to having it removed. Yeah, having it removed, because affordable housing projects, they can actually quantify the impact on affordable housing projects as they are built now, and including in Mo'iliili, and it's quite significant. And so for that reason, I guess I don't know what you're going to do after this hearing. I know there's a request to move it, to postpone it, but with regard to that issue, I just wanted to let you know that I now better understand the implications.
Okay, thank you very much. Councilmember Wire.
Thank you, Chair. Yeah, I mean, I just first want to share that I have complete respect for everybody that's been a part of the conversation, and I think they've brought a lot of value and added value. And I wouldn't pretend to have the exact answer on every policy issue. I know we just talked about reducing, the 300-foot minimum in the Bill 7 and the affordable housing projects we just did. And so, don't want to undervalue the impact of cost on housing. I do feel a little uncomfortable with the wind requirement changing, especially when you're looking at just where all of our planned development is going to be over the next few years in Central Oahu and the Ewa Plain. Understanding, like Councilmember Dos Santos Tam said, our communities are facing increased insurance costs. Have HOAs freaking out in our community, and of course, a lot of that is based on impact and payout that insurance companies have to do. And so the more we develop in a way that doesn't minimize those risks, I think we have potential to see that. It really was just that, knowing that government policy is shelter in place. Where do we have planned development? Where do we expect people to go? Understanding we want to balance it with housing costs, understanding that we're actually changing the code as it currently is, right? We're reducing restrictions. I mean, I'm all about not adding anything more. I can say that because I think there's too many barriers, but we're actually today saying, let's take a step back a little bit, which may be appropriate. I mean, I'm not saying anyone's wrong in asking for that, but just wanted to kind of share my thoughts. So appreciate the opportunity for the discussion.
Budget Chair, you'd like to share your thoughts before we call for the question?
We had a robust discussion even in the last committee when we talked about this. My position hasn't changed from in the same tune that Mr. Arakawa shared, so would recommend those suggestions by Mr. Arakawa.
Okay. Everyone has said their piece. At this point in time, then, the chair would like to make the motion that we recommend to pass it out for third reading. and this is the motion. I think for all of us, we've heard a lot of different perspectives on the windborne debris and the tsunami loading provisions in the bill. For me, it came down to weighing public safety risks against the cost to build and provide housing for our residents presently. So the chair recommends that Bill 65 of 2023, Committee Draft 1, be amended to a Committee Draft 2 that will incorporate all of the amendments I had proposed in Council Communication 155 of 2024, which includes the line item 3, Councilmember DeSantos Tan proposed amendment, but does not incorporate line item 17 on page 7 relating to windborne debris. 2, we retain the windborne debris provisions under Table R 301.2.1 and Section R 301.2.1 that are currently in the Committee Draft 1, which sets the wind speed trigger at 140 miles per hour, and amends the definition of windborne debris area in the Building Code section of 202 to set the wind speed trigger at 140 miles per hour, as set forth in line item 1 of Council Communication 16 of 2024, which was previously posted on January 31st, 2024, but line item 1 was not accepted at the Zoning Committee meeting on February 7th of 2024 and was taken out or taken under advisement at that point in time. So that is the windborne debris provision. Number 3, in the tsunami loading provisions in section 1615.1 and 1615.2, we delete the applicability of the tsunami loading requirements to risk category 2 buildings so that the tsunami loading requirements only apply to risk category 3 and 4 buildings as set forth in line item 3 of Council Communication 16. Line item 3 was taken under advisement at the Zoning Committee on February 7, 2024. So are there any discussions, objections, or reservations? Hearing none, the bill has been amended to a Committee Draft 2. And now the chair then recommends that Bill 65 of 2023, Committee Draft 2, be reported out for passage on third reading. Any discussions, objections, or reservations? Hearing none, so ordered. There being no further business, the meeting is adjourned.